Good morning, Ms. Miley.
Good morning, Chief Justice Marshall. Good morning, Your Honors. This is Crystal Murray appearing on behalf of Hector Guerrero Avila in his conviction of first-degree murder based on two theories, premeditation and extreme atrocity and cruelty. And once again, apparently, having just sat through the first argument, we are concerned about an absent medical examiner, and we are concerned about testimony at trial from a medical examiner who was not present at the autopsy, but nonetheless was allowed to recite the findings and data.
Now, why was the examiner not available in this case?
He had left the office and moved to Albany, New York. He apparently was available.
Well, is your position that can never happen? A medical examiner, once they do an examination, they have to testify.
Yes, I would say within, well, the problem is that the medical examiner, as an expert,
Well, what if the examiner happens to die after they do the examination? Then there has to be another examination, you would say.
Then they're unavailable. In this case, the district attorney puts on the record that she could probably bring him in. So I think this whole situation is not just this case, but maybe the situation in this jurisdiction is being skewed because we have such a revolving door on the medical examiner's office. But in general, we bring experts in from all over the country. I don't see the problem in bringing in Dr. Phillip from Albany, a 2-hour car ride. The point is that
Not 2 hours.
Pardon me?
Not 2 hours within the speed limit, I can assure you. Either that or you haven't been to Albany.
But here, the prosecutor chose to put Dr. Mark Flomenbaum on the stand. And we are not concerned with the fact that Dr. Flomenbaum gave his opinions as to the cause of death and the mechanism of death based upon Dr. Phillip's facts. That's not our argument. Our argument is that under DYS versus a juvenile, that the facts and data, underlying facts and data, the facts and data in the autopsy report were not admissible on direct examination.
I should remember this, but I don't. What's the status of whether this was preserved or not preserved, that particular argument?
Defense counsel did not specifically object to the admission of the facts and data on direct. However, when it came time for his cross-examination, he did make it very clear to the judge at sidebar, make clear his frustration that he did not have the examining doctor at trial. It came up with where he was trying to cross-examine on the competency of Dr. Phillip. And of course, he was not allowed to because Dr. Flomenbaum couldn't speak to that. So he made his frustration at the fact that the defense was inhibited or the defense was hurt by not having Phillip there at sidebar. But
can I ask you this?
Sure.
Was cause of death, for example, really disputed here? Wasn't he shot in the back?
Well, that was disputed, but the cause of death, the fact that he died from gunshot wounds and the mechanism of death was hemorrhaging was not in dispute. What, as I have described, what I have argued in my brief, is that the problem arises because the district attorney at trial, in order to prove premeditation and extreme atrocity and cruelty, depicted what she called an execution-style murder. Now, her problem was that one witness had seen the entire shooting incident. So, in order to do that, she had to put this execution-style scenario together by basing it on the facts and data from the autopsy. And that's, as you can see in my brief, where I do recite at length, I believe, that Dr. Flomenbaum talks about the number of gunshot wounds. We wouldn't even know that without Dr. Phillip. The location of the wounds, which he then describes the paths the bullets took. He describes one bullet that does exit the body, fighting to get out and being shored up against what he then is allowed to opine to was pavement. All of that information comes from Dr. Phillip. And it was based on, I'm sorry, Judge? No.
Finish.
It was based on that the district attorney got what she wanted, that this was a scenario that the deceased, Crespo, was felled by a frontal bullet, and then he received a fatal wound from the back by a gun pressed up against his spine while he was down on the ground.
So
And
the
there
difference,
just isn't evidence of that.
the difference, because the witness, Mr. Milliken, right, talked about seeing, did he see the first shot?
He did not see the first
Okay,
shot.
so
He heard the first shot.
He
and that
heard the
caught his
first shot, he
attention.
saw the victim on the ground, but he saw the arm extended and some more shots. So you would get more than one bullet from him.
Oh, there
anyway.
was no question there was 2 bullets, or
So-
2 shots.
So it's
I'm
the
sorry.
question of where the gun was?
There's a question of how many gunshot wounds, really, to begin with, if you're going to be very technical here. And the entrance, we don't know,
But you certainly get from him the idea that the killer is shooting the victim while he is on the ground, shooting him again.
Well, I don't know if I agree with that, Your Honor. Milliken testifies that he's out in the street with his tenant, and he hears a gunshot. So they look up, and they see a man fall to the ground. But the man then struggles to get up. And he cannot say with any certainty whether the man had been on his back or on his stomach. He's just struggling to get up. Then and I think this is really important because Milliken's a disinterested witness, he sees the man extend his arm.
The shooter.
The shooter extend his arm, and he hears the second crack. Now, why that's important is that the Commonwealth then tries to say that, that basically contradicts the idea that the deceased was on the pavement. Milliken doesn't say he leaned over or he bent over. He says he extended his arm.
But couldn't the Commonwealth, just from that information, argue that was an execution? I mean, isn't that a reasonable depiction?
That he was shot again the second time? I don't think that does it, Your Honor. They just say he's got his arm out like this. He extends his arm and shoots again. We don't know whether it was front, back, whether it went through. None of that information comes in without the medical examiner's facts.
But didn't you have Mr. Zambella, the criminalist who was there, and didn't he testify that the bullet entered through the back of the jacket and came out through the front, and wasn't the jacket part of the evidence in the case?
Zambella testified that, in his opinion, it was a contact shot to the back.
Contact shot meaning?
Meaning up against
Right up
the
close.
jacket.
Oh.
But he was at the autopsy, yes?
No. Mr. Zambella?
Well, I was trying to
But
figure out
Zambella
what...
testified. He's the criminalist.
Right, but when you said was there, you mean was testifying?
He testified at
Yeah.
trial.
He testified that, and it was based on the fact, as I recall, that the fibers of the jacket were oriented in an inward direction.
So wouldn't
But
that be...
again, I would say that that's disputed again by Milliken. I mean, how do you shoot someone with a gun up against a jacket if they're on the ground unless you lean over and get down there?
Did Mr. Milliken say at what angle the arm was stretched out?
No. No, he does not. Nor does he say anything about what happened. I mean, he doesn't say he saw the gun connect or the bullet
I
connect.
understand that, but I mean, the jury had before them the evidence of the criminalist, and they had before them Mr. Milliken's testimony, and why, even if you take out all of the autopsy information, why would that be not sufficient for the if you look at the sufficiency of the evidence test, why would that not be sufficient for the jury to conclude that he had been shot at close range from the back, and from that to conclude that it was, quote, execution style, because there was no question that it came after the first shot?
No, Your Honor, that's in dispute. Even Dr. Flomenbaum and would not commit himself to the order in which the shots
No,
took
I'm talking
place.
about Milliken. Milliken says...
Milliken, right, okay, sorry.
Milliken says, I heard a shot, didn't see it, saw somebody struggling to get up, getting up, whatever the words were. And then I saw a hand extended, and then there was a second shot,
Right.
right? And then you've got the criminalist saying, this bullet wound, a bullet is consistent with, from the back, close range, up against, and they can conclude from that that this was a deliberate execution-style attempt to kill somebody who had been injured. I mean,
Well-
those are not piling on inferences, it seems to me, even if you take out all of the autopsy
No,
stuff.
I understand that, Judge, but I think that, right, if Flomenbaum had been limited to testifying to what he could testify to, that the deceased died from multiple gunshot wounds, and there was the evidence that Your Honor just outlined, I don't think that's extreme atrocity or cruelty. I think even the judge had a problem at the charge conference in the instruction on atrocity and extreme atrocity and cruelty was opposed by defense counsel. But even the judge clearly felt it was weak evidence. He commented that the only Cunneen factor that he could see at all was indifference to suffering. So I think it's a very weak case, and I think that if we didn't have the facts and data from Philip, we would not have a substantial case for extreme atrocity and cruelty.
But what about deliberate premeditation?
That he shot him at close range?
No, that he shot.
The jury did
Multiple
find,
shots.
the jury did find that theory as well.
You know, I understand that. So I'm
Yeah,
saying, so even if you are correct on extreme atrocity and cruelty, one is left with deliberate premeditation, and it seemed to me that if you accept all of Milliken's testimony,
Right.
don't you have deliberate premeditation?
I don't think so, Your Honor. There's also evidence, as I say again, Milliken contradicts Zambella, and you have Cruz, whose credibility is certainly the subject of a lot of this case, but you do have Cruz. I lost my train of thought. You have Cruz saying that when the deceased got out of the car, he came at him with a purpose. And because we don't have any more, I mean, Cruz takes off, flees as soon as the first shot is fired. So we don't have anybody filling in gaps here. Just to say that because it was a second shot, or the second shot happened to be a close shot, I don't think that necessarily shows premeditation without more.
Could we turn now to that
Certainly.
issue, to Cruz and the question about the Bowden, not the instruction, but the...
No, I understand, Your Honor.
Allowing his statement and various other things. One sort of preservation question. You say several times that the judge didn't give limiting instructions, but I think the Commonwealth says, maybe it's just a question of time, because I think the Commonwealth at least says that he gave a very long limiting instruction in his final instructions. Is that right?
That is right, Judge.
The
and
use of this evidence.
When I said that, I was referring to the introduction of the written statements. Those were handed over to the jury without any limiting instruction at all. And
also they weren't referred to in the final instructions? The
they
written statements?
were included in the final instructions.
They were, but not in the,
But my concern where a jury, and certainly the courts made clear that there's great concern whether a jury can really distinguish between evidence for probative purposes and not. If you look at, say, the case law, and the closest I could get to this was in the area of fresh complaint. In fresh complaint law, this court has said the judge will seasonably or
Right. You have to do it both times.
You have to
Yes.
do it both times.
Right.
And I would make the same argument
Yeah.
here.
What, you had testimony from the investigators or detectives, basically about why they conducted their investigation and stopped looking for other people.
Right.
Why did the statements come in? The written statements? That is Cruz's written statement? I mean, what was
The written statements, it was just one more argument that the jury was entitled to see the statements of Pedro Cruz in order to evaluate the motives of the law enforcement, of the officers, in determining whether they should or should not have done what they did. In fact, as defense counsel argued, I mean, the statements were not written by Cruz. Cruz never even authenticated the statements. They came in, it was Trooper Gravini, one of the lead investigators, who took down, not the questions, but at least took down some of Cruz's answers.
Now, Cruz's first two statements were false, right?
Well, that's interesting. The shooting happened on November 6th. And Cruz comes in and he gives a statement to the police that night, which is very far-fetched.
He says a black guy shot him, right? That's false, right?
That's false. And then
Okay.
2 weeks go by, and the police bring him in for an interrogation. This is now statement number 2 on November 20th. Statement number 2 is pretty close to what Cruz's trial testimony is, with one huge exception.
He
that
doesn't know who the shooter.
name who the shooter is. He still claims he doesn't know the shooter. Now, the very next day, he gives his third and final statement, which is very identical to statement number 2, except that now he puts the gun in the defendant's hand. So those were the 3 statements. The last 2 differing only by the incrimination of the defendant and really being pretty much the same as his trial testimony.
And was the defense, it wasn't that Cruz was the shooter, it was that the police failed to find other people beyond Cruz and this defendant?
The defense was that Cruz was a liar from start to finish.
Okay.
And certainly with strong implications that he was the shooter.
But that isn't really a Bowden thing, is it?
No. And then in addition to it, it was the Bowden challenge, that there were 2 very strong, I would say, very specific leads of 2 other suspects, drug dealers, that the Lawrence Police Department was aware of that could easily have been the people who shot Cruz. And, I'm sorry, Crespo. And it was those suspects where the investigators had to admit they really hadn't done anything.
But they had the exchange of telephone calls just immediately before the shooting, didn't they?
They did, and it was actually one of the elements of Detective Laird basically giving his opinion of the defendant's guilt, and thereby his opinion of Pedro Cruz's credibility, is that the telephone records did coincide with Pedro's account of what had gone on the day of the shooting.
Regardless of what Pedro's account was, the bare facts were there were exchanges of phone calls between.
Yes.
Ms. Murray, could I just go back to the gunshot, which you're saying, you know, you're objecting vigorously that Dr. Flomenbaum shouldn't have testified. Was there a serious issue here as to the direction of the bullets and how many bullets and so on and so forth?
Yes, I think there was, Your Honor, because,
Does
for
defense
example,
counsel retain a ballistics expert?
No, he did not.
Was there?
There wasn't an issue in that respect, but I think what was
What do you
very
mean
important
in that
here.
respect? Don't you need a ballistics expert to say, no, this, you know, the guns didn't enter this way, or did, or were criminologists?
Well, I was thinking more in terms of the fact that what was very harmful here was the testimony about one of the bullets creating a shored exit wound, meaning that it met with resistance as it was, as Flomenbaum said, as it was fighting its way out, because then that was a prelude to objected to evidence that what was resisting it was the pavement.
In those circumstances, would it have been necessary for defense counsel to have retained a ballistics expert? This is a claim that your client has made.
I don't think, no, not in terms of the direction, the paths of the bullets inside the body, no.
Well, on the one hand, you're saying to me that the damaging testimony which supported the Commonwealth's case of execution came from a ballistics expert. On the other hand, you're saying you don't need a ballistics expert.
Well, what I'm saying is that the fact that it was a short exit wound, for example, was not in dispute. But the fact that the jury heard about it was very harmful to the defendant's case.
Thank you, Ms. Murray.
Thank you.
Ms. Semmel?
Good morning. Catherine Semmel, appearing for the Commonwealth. I'd like to talk about the Nardi issue, the hot issue this morning. And I'd like to address the preservation issue first, because the Commonwealth's position is that this issue was most definitely not preserved. Dr. Flomenbaum testified completely on direct. And
with no objection at any point?
With no objection at any point. The issue of the substitute ME of Dr. Phillip being in Albany came up on cross-examination of Dr. Flomenbaum when the Commonwealth, in fact, objected to defense counsel trying to elicit from Dr. Flomenbaum his understanding of Dr. Phillip's qualifications. At that point, there was a discussion. You know, he's in Albany. The Commonwealth noted. The judge happened to note as well. Well, if you're challenging the substitute ME, it's a little late for that. But defense counsel never suggested he was challenging it on that basis. In fact, he didn't seem frustrated at all by the situation. He seemed to be, you know, as good defense counsel will, taking full advantage of it so that he could cross-examine not only Dr. Flomenbaum about his qualifications, but point out that he's not the one who conducted the autopsy. So I don't think by any stretch of the imagination that this point was preserved, which is important for the substantial risk standpoint.
When was the trial in this case?
2003, I believe.
So
No.
long before Nardi.
Is that right? No, that can't be right. Oh, I'm sorry.
That's okay. It was long before Nardi.
The offense was in 2003. The trial was in 2006. I'm sorry. Yes, it was long before Nardi. And another point I'd just like to make at the beginning is I think that this is an unusual case in that in addition to the ME's testimony about the nature of the wounds and so forth, there is a lot of other evidence that came in, which I'd like to discuss in more detail, which is important for the substantial risk standard. But I would like to note as well that despite this, the cumulative nature, I think whatever guidance the court can give to the Commonwealth about the breadth of testimony that's admissible in this circumstance would be extremely helpful. Especially because this is a very different case than Nardi was, and different issues arise because I think we're talking about gunshot wounds. And the Commonwealth's position is that Dr. Flomenbaum could testify, you know, at a minimum, that the cause of death in this case was 2 gunshot wounds, 1 wound to the back, perforating the aorta, 1 wound to the lower torso, perforating the kidney. I think the Commonwealth and the defense are in a lot of agreement about what expert opinion Dr. Flomenbaum could give. I think the one difference we have is as to the location of the wound, which coincidentally is, of course, a very important piece of the Commonwealth's case here, that this was an execution style.
Could I just ask you about the not the 2 gunshot wounds, but that 1 perforating the back and 1 perforating the kidney?
I'm sorry, the aorta in the kidney, or do you mean the fact that it was on the back?
Sorry, the aorta in the kidney.
Okay.
Is that, where is that coming from? In other words, when Dr. Flomenbaum testified, that's where those shots, what those shots did. Where was he getting that information?
Well, I think it is his opinion as to the cause of death based on the underlying information in the autopsy report.
So he's getting it from the autopsy report.
He's getting his underlying information, and then his opinion as to why this individual died is that he died because a gunshot perforated his aorta and his kidney.
And under juvenile, isn't that precisely where we said you've got to have the underlying facts be able to be brought in evidence?
You have to, I'm
The
sorry.
on cross-examination, I mean, I know Mr. Graham objected to what he called burden shifting, but that if the defendant wants that on cross-examination, wants to challenge the person who's putting those, whatever those facts are. Was there a challenge here?
Was there a challenge
On cross-examination?
to the basis of the autopsy report? I don't think, no, I don't think this is a case where there was, where the defendant had a lot to gain from the autopsy report, to be quite frank. This is not a case like Nardi, where the defendant wanted to get an information from the autopsy report, if that's what the court is asking. I don't think that's the case. I think in general, the autopsy report information was favorable to the Commonwealth's case. The defense
No,
didn't.
my point was, it was, you know, even under DOIS against a juvenile, you could testify to facts, but an expert can, and Dr. Flomenbaum did here. But if there are facts that would be admissible, I mean, you don't have to bring you know, you don't have to admit them in every case. But if the defendant wants to cross-examine on that basis, then the witness has to be available.
No. Well, I think, wouldn't it be that you can't testify to facts that aren't in evidence, but you could testify to the opinions drawn for them? And I guess my question was, I can understand how Dr. Flomenbaum could testify to his opinion that he died from gunshot wounds. But I think, and maybe this is what the Chief Justice is asking, once you get to where those gunshot wounds were, the specifics about where they were, that isn't really his opinion. That's really restating a fact that is in the report.
That's what I'm saying.
Well, I disagree, Your Honor. I think, and quite frankly, the defense doesn't make this argument. The defense agrees that this is part of the cause of death, at least the aorta in the kidney. I think this is, you know, a very encapsulated version of why the person died. He had a gunshot wound to the back. It struck his aorta. You know, I think that is the minimum that the Commonwealth should be able to get in. It's not. I mean, it's part of the cause of death. 2 gunshot wounds tells the jury nothing about why the individual died. So, yeah, I think we have to get that bare information in. Where the wound was.
What I mean, the test isn't what you need. It has
no,
some
it's
other
not. But it's what's the opinion? What's the opinion as to the cause of death? And that's part and parcel of the cause of death. I mean, it's stated in the most minimum terms I think possible. That's why he died. He didn't die because he had gunshot wounds. He died because he had gunshot wounds that struck his aorta. And the part about the location is where I think the defense and the Commonwealth disagree. And I would suggest to the court that, you know, if you look at, you know, just anecdotally, I guess we refer to some cases from this court when they refer to the cause of death was a stabbing to the chest that struck the lungs. You know, the location of the wound is I think also just part of the very basic nature of the wound. And I think if we think about a more complicated case where there are multiple wounds to the individual, it's very confusing to jurors to try to make sense of it without just the basic. It was a gunshot wound to the back striking the aorta, and that the location of the wound is also bare minimum of what you need to show jurors why the person died, for jurors to be able to link the medical cause of death with the assaultive act that's at issue. And so I suggest to the court that's the minimum of what of what's encapsulated in the cause of death testimony. The other part of Dr. Flomenbaum's testimony, which is I think a different issue than Nardi, but which is also admissible, is where Dr. Flomenbaum himself examined pieces of evidence and testified as to his opinion as to those. Now that's with regard to the bullet, which was nothing to do with the autopsy report. He viewed the bullet and he explained from the bullet, which had been removed from the scene by Trooper Coleman, his view that it was consistent with having struck a hard object such as pavement. The one thing that I would like to also point out to the court, because I don't think I mentioned it in my brief because I noticed it last night when I was reviewing Dr. Flomenbaum's testimony, there is one point in his testimony, as at page 127 of transcript 5, where Dr. Flomenbaum is looking at a photograph, I think it was exhibit 32, and he was testifying as to the nature of the exit wound based on his viewing of the photograph in that case. And I think the Commonwealth may have conceded too much when I said in my brief that I thought that the shored nature of the wound was something that he was really relying solely on the autopsy report for, and may have been impermissible under Nardi.
Was there cross-examination on that point that you could tell the direction of a bullet wound from a photograph?
It wasn't.
I don't mean an objection. I mean a cross-examination.
I don't think so. I don't think so, Your Honor. No, there was very little cross-examination about the specifics of Dr. Flomenbaum's testimony.
I take it it's well within the expertise of a medical examiner viewing photos as to two wounds. One's an exit wound and one's an entrance wound. That sounds to me like something that you'd be able to testify to having just observed a photo.
I think that's true, and I think that if you look at Dr. Flomenbaum's testimony, you will see that he describes what about the photo tells him that that's an exit wound, and describes what about the photograph of the wound.
Okay, that's the same thing. I mean, it's not just a casual statement. There's an explanation as to why he's looking at something.
That's correct, Your Honor. So I think, again, from the substantial risk standard, I think we have to look at...
substantial likelihood standard.
Thank you very much.
Sorry.
You have to look at what Dr. Flomenbaum could permissibly say about the cause of death, what Dr. Flomenbaum could permissibly say based on his own expert opinion from having viewed various items of evidence in this case. And then you have to look at how much the reference to the autopsy reports really bolstered his opinion. And I think the answer is not very much, particularly when you have the cumulative nature of Dr. Flomenbaum's testimony. And I would point the court to a couple of things which have already been alluded to that also supported the Commonwealth's theory of the execution-style killing. And that is Mr. Milliken's testimony, which certainly lent an inference that the victim was shot, was on the ground, struggling to get up when he was shot again, which tended to support the Commonwealth's theory. You have as well Trooper Coleman's testimony about the bullet that was embedded in the front of the leather jacket, and his testimony that it appeared to have struck a hard object such as pavement. You have Dr. Flomenbaum's permissible testimony to precisely the same thing based on his review of the bullet. And as Justice Gantz alluded to, you have Mr. Zambella's testimony, which I think is really important in this case for assessing the impact of Dr. Flomenbaum's testimony, because Mr. Zambella, the criminalist, from a different angle, reached pretty much the same conclusion as Dr. Flomenbaum based on his analysis of the jacket, which is that there was a hole in the back of the jacket which had an inward orientation. There was a hole in the front of the jacket where the bullet was embedded that was apparently the exit from the jacket. And from that, we have really the same inference that the victim was shot in the back. And taken in conjunction with testimony concerning the bullet, you have the victim being shot in the back while he's lying on the pavement. And all of that was permissible. And from a substantial risk standard, I think that's extremely important. Does the court have any further questions about the Nardi issue? If not, I'll move on to talk about really kind of a messier issue, which is the statements of Mr. Cruz. There's a couple of different issues here. One is Detective Laird's testimony that at some point the investigation became fixed on the defendant. And just as a precursor, I'd like to note that, at the time that Detective Laird testified, Mr. Cruz had already testified and had been cross-examined at length by the defendant about his various statements to police. And I think we've encapsulated that a little bit in our brief in a very long footnote. At that point, Detective Laird had also been cross-examined about the police investigation, as well as what Mr. Cruz had told them at various points. And at that point, I think the Bowden defense had been fully set up, as I think the defense says, by the defendant. It was not until the redirect examination of Detective Laird, when all this information was out there, the defendant had gotten in hearsay testimony about different leads that had not been pursued and so forth, that the Commonwealth asked, well, after you got Mr. Cruz's third statement on, I think it was November 21st, what factors led you to focus on the defendant? Now, there was an objection on that point, and the judge overruled it because he said that the Bowden issue had been vehemently pursued by the defendant, and the Commonwealth was entitled to offer some explanation. And then I think consistent with Lodge, the court at sidebar ascertained from Detective Laird what he was going to testify to, just to ensure that it wouldn't be inappropriate. And in fact, in a kind of not very eloquent answer, I think Detective Laird answered by saying, at that point we focused on the defendant because Mr. Cruz's explanation of what happened was consistent with other information we had from the cell phone records and from other witnesses. And that was the sum and extent of Detective Laird's explanation for that. And I think that is really a very different situation than Lodge. The nature of the Commonwealth's question did not invite and did not get the kind of broad-based response that you got in Lodge, where the officer went on to summarize all of the evidence of guilt against the defendant. In this case, it was kind of a snapshot question. On this day, what led you to focus on the defendant? It was clearly early in the investigation. This was the first piece of direct evidence they had of the defendant's involvement. And I think it was that kind of preliminary assessment and explanation that did not summarize the defendant's guilt.
Why did you need to introduce the written statement that I guess maybe it's Detective Laird or there's another officer who testified.
Gravini.
So it was his notes, I guess, right? Gravini's notes?
I think so, yes.
So Gravini testified orally about the same things as Laird did? That is, this Bowden issue? About why we focused on why we focused on the defendant and why we believed Cruz?
Gravini offered a lot more detailed testimony. He testified after Laird, and the Commonwealth did ask him lots of questions about what Cruz had told him at various points at that point. And as to why we introduced
And was there a limiting instruction at that time?
Late in his testimony, this is why I'm sorry I described it as kind of messy, because Trooper Gravini testified to a lot of information about what Cruz had told him with no objection from the defendant. The objection from the defendant first came when he was tying in Cruz's explanation of what happened with the phone records, and the defendant objected to that. And then there was a question, after really lots of testimony had come in, there was a question about, well, did the defendant tell you to meet him on Brook Street? And at that point, for the first time, very far into things, the defendant brought a hearsay objection to that. I'm not sure why then. I can't quite figure out why then he brought it. The judge agreed with him and gave limiting instructions then that encompassed not just that statement, but really I think encompassed everything that Cruz had told the police. Okay. And I think the judge was fairly clear, and in fact he reiterated it, I think, a page later in the transcript on his own. Here's an example of, you can't take whatever Cruz told police is not substantive evidence of what happened. Only what Cruz comes in and testifies in court is substantive evidence of what happened, and he reiterated that in the final charge. So I think the limiting instruction was fairly clear once an objection was brought.
Now, is there anything in that written statement that goes beyond what Cruz testified to at trial?
I don't recall anything specifically, Your Honor, and I would just note that the judge, before he introduced the written statements, they went through the written statements line by line, and the judge redacted things that he thought didn't go to the police motivation, that he thought was too inflammatory, or that didn't go to why the police pursued a certain action. So the statements came in, but not in totality, and the judge did look at them first. As to,
to me it seems like total overkill.
It's, I'm not sure that it was necessary to put the statements in, Your Honor. I'm not. I think the reasoning at that point was that there had been so much talk and in a disjointed fashion throughout the trial of what Cruz said here and what Cruz said there, and clearly he'd been lying once and he'd been lying twice, and I think the judge wanted the jury to have the clearest picture possible of what had happened, of what Cruz had told police, and that was the way to get it, and that he felt it was appropriate given the Bowden claims. And I think we referenced in our brief too, although the judge, nobody ever used these magic words, I think that the judge was also looking at it from the doctrine of verbal completeness. There are some references he made at some point which suggest to me that that he was looking at it from that perspective. Does the court have any further questions? Because I'd be happy to rest in my brief for the remaining issues.
Thank you, Ms. Semmel.
Thank you very much.